As an open economy, Canada has very few limitations on foreign investment. Throughout the years, Canada has seen investment from all over the world. Most investment comes from the United States, but we have seen transactions coming from Europe and Asia as well. Generally speaking, there are very few significant regulatory requirements which must be satisfied when conducting an M&A transaction in Canada. The Investment Canada Act applies when a non-Canadian purchases a Canadian business. For investments originating from WTO member nations, only high-value transactions having an enterprise value of more than $1 billion Canadian dollars are subject to review. There are, however, a few exceptions. Lower review thresholds apply for acquisitions by state-owned enterprises. These acquisitions are reviewable when the value of the assets of the Canadian business being acquired exceed 416 million Canadian dollars. Even lower thresholds apply to acquisitions of cultural businesses such as publishing, film, music, and broadcasting. In addition to the Investment Canada Act, certain industries such as banking and airlines have specific foreign ownership restrictions. For transactions which have a connection to Canada's defence industry, sensitive technologies, or which involve companies critical to the provision of goods and services to Canadians, there is a national security test, similar to the US CFIUS process, which can prohibit these transactions. In Canada, the main form for an M&A transaction is a plan of arrangement. A plan of arrangement usually involves a negotiated transaction between the purchasing company and the target and requires the approval of the target company's shareholders. Typically, approval from 2/3 of voting shareholders is required, and the transaction must also be approved by a Canadian court. This acquisition structure is very flexible and can address securities law, tax law, and corporate commercial considerations all in the same transaction. Arrangements also have the advantage of resulting in the acquisition of 100% of the target company in a single step. Another typical form of M&A transaction is a takeover bid. Takeover bids are subject to the rules of the Canadian securities regulators and involve an offer made by the purchasing company directly to a target company's shareholders. Often takeover transactions are negotiated, but they can be conducted on a hostile basis with an offer made directly to shareholders without the support of the company or its board of directors. Often a takeover results in a multi-step process to get to 100% ownership, which can add time and cost to a transaction. Recent changes in our Canadian securities laws have required that an unsolicited takeover bid remain open for acceptance for at least 105 days. While the 105 days represents a long time to have an offer remain open for acceptance, Canadian securities regulators have balanced this by severely restricting defensive tactics which could be employed to stop a bid from being considered by its shareholders. If the transaction turns friendly, or in a competing bid scenario, there is the ability to shorten the deposit period. Before an acquiring company can take up shares tendered to the takeover bid, at least 50% of the target company's shares must be tendered in acceptance of the offer. It is common to see investors from outside of Canada make minority investments in Canadian businesses before undertaking a merger transaction. These minority acquisitions can trigger reporting requirements. Any acquisition of greater than 10% of a public company's shares requires the filing of an early warning report and an insider report similar to the filings required under US securities laws. In Canada, public market acquisitions greater than 20% of a company's issued and outstanding shares may trigger the application of takeover bid rules and require an offer to all shareholders. For this reason, parties seeking to obtain a minority interest often limit their purchases to less than 19.9% of a company's shares. Special rules may apply to a merger and acquisition transaction conducted by a company insider, which triggers enhanced governance requirements and independent valuation requirements of the shares of the target company. As these rules can be somewhat complex, it is always recommended that purchasers looking to undertake a minority investment do so in consultation with Canadian legal counsel. As Canada's law firm, BLG is well organized to assist clients from all over the world who wish to undertake M&A transactions in Canada. Our 5 BLG offices across Canada can each field a team of experienced M&A lawyers to provide the services required to complete the corporate, securities and tax law analysis for our clients, advise on operational matters, and assist in local due diligence. With access to BLG's industry-leading national platform, we also provide seamless advice and service from our many specialist lawyers.